Oh, I'm starting to record now, and welcome to the uh, the lecture on liberty. So I've titled this "Liberty and Prohibition of Discriminatory Detention," and again, like the legal capacity lecture, I've changed this somewhat from the material, from the way I approached the lecture in the spring. This time I'm really focusing a lot on the basically the legal standard, what's available to us to make the arguments in a legal human rights framework, um, to abolish psychiatric detention as a discriminatory deprivation of liberty. And I think I've de-emphasized in this the personal experience, but I think our personal experience is always relevant to thinking about why we have to frame it in the first place. Why isn't it taken for granted that this deprivation of liberty is discriminatory? Why on the other hand do we react against it and say it's discriminatory? What is the political conflict going on about it? So our personal experience, and also how we understand the oppression that's being enacted. What is this discrimination? Where does it come from? Why does it exist? I recognize that sometimes in dealing with the legal framing of it and what the CRPD committee says, what the Working Group on Arbitrary Detention says, that can sometimes get depoliticized, because in the UN there's often somewhat of a kind of counter pressure, because the UN is made up of member states, and even the expert bodies are they're kind of in an interdependent relationship with the member states, and really in some sense, in the greatest sense, a dependent relationship, because the member states could defund them, for instance. But so they have to, at times, there's an incentive to be careful in what they say and not to politicize things too much. But I think that that's all fair to bring in everything contextual from your experience and from your knowledge and from your theory, whether it's MAD studies or disability studies or whatever framework you may want to bring in on it. So, okay, let's start. On the text and the origin of Article 14, I've outlined the kinds of the issues that I see in the text, and then we're going to actually examine the text. So, what issues in the sense of what is the purpose of Article 14, framed as the right to liberty and security for the person? Why is Article 14 in the Convention? What injustices is it trying to remedy? So the first issue that, of course, has been my greatest concern is the prohibition of involuntary hospitalization, involuntary institutionalization of people with disabilities in disability-specific settings like mental institutions, psychiatric institutions, as a form of discriminatory detention. The second one is a guarantee of non-discrimination in processes of arrest, in processes and conditions of arrest and detention, especially related to criminal charges. So liberty and security of the person on the one hand, it's the right that grounds us in advocating for the prohibition and the abolition of the discriminatory detention like psychiatric commitment. And it's also important for people with all kinds of disabilities, including people with psychosocial disabilities, to have the guarantee of non-discrimination if we're in a situation of being a criminal suspect and going through a criminal trial, and if we are convicted of a crime. So that's the second prong, the guarantee of non-discrimination and enjoyment of the CRPD rights as part of humane treatment. So one of those is, of course, the prohibition of forced psychiatric interventions. And in my country, in the US, there's quite a lot of forced psychiatric intervention going on in the prisons. And okay, so that's another piece of it. Generally, the third prong that I would say is the general principle of enjoyment of liberty and security of the person on an equal basis with others. Equal basis with others is how the CRPD rights are framed in general. And you'll see in the CRPD Committee's draft general comment on equality and non-discrimination, they're making that point that throughout the convention, all the rights are guaranteed on an equal basis with others. And that's important as a kind of catch-all, and also to note that security of the person, there's liberty of the person, and security of the person is related to liberty, but it also can be separate. And according to the Human Rights Committee, in one of their recent general comments, General Comment 35, they have said that security of the person is a guarantee against, I'm not sure of their exact wording, but essentially against interventions by the state against a person's physical and mental integrity. And it doesn't have to be within the context of the state already detaining the person. So security of the right to security of the person on an equal basis with others is an alternate basis for the prohibition of forced treatment and mental health services, in addition to the right to legal capacity and the right to be free from torture and other ill treatment. And you'll see that the CRPD Committee, in their concluding observations and in the guidelines on Article 14, they include the right, they include the obligation that states must ensure that health services, including mental health services, are based on the free and informed consent of the person concerned. They include that under Article 14. So this is the text of Article 14. And you'll see two of the prongs that I mentioned in the first slide. States parties shall ensure that persons with disabilities on an equal basis with others, A, enjoy the right to liberty and security of the person. So that's the statement of the general principle, the catch-all right on an equal basis. And B, are not deprived of their, B, that persons with disabilities are not deprived of their liberty unlawfully or arbitrarily, and that any deprivation of liberty is in conformity with the law. Those two parts are actually still part of the general principle of the right to liberty and security of the person on an equal basis with others, and that the existence of a disability shall in no case justify a deprivation of liberty. And that's the language that prohibits disability-based detention. And sometimes I have framed that as detention on the basis of disability, where disability is part of the legal ground for the detention, or in disability-specific settings where even if they don't say disability is part of the reason that on which they want to justify the detention. When you're locked up in a psychiatric institution, actual or perceived disability is inherently, the reason, part of the reason of the detention, even if they don't say so. This next part, paragraph 2 of Article 14, is really about the equality and non-discrimination guarantees in arrest and detention and conditions of arrest and detention. States parties shall ensure that if persons with disabilities are deprived of their liberty through any process, they are, on an equal basis with others, entitled to guarantees in accordance with international human rights law, and shall be treated in compliance with the objectives and principles of the present convention, including by provision of reasonable accommodation. So the first part that I haven't read, on an equal basis with others, entitled to guarantees in accordance with international human rights law, that's the general principle of guarantees of equality and non-discrimination, or that on an equal basis entitled to the guarantees protecting the rights of people who are deprived of their liberty, that people with disabilities are entitled to those guarantees in human rights law on an equal basis with others. And the additional right that the people with disabilities have a right to be treated in compliance with the objectives and principles of the CRPD. And that actually allows us to bring in all of the rights in the CRPD to the extent that they apply, to the extent that they can be fulfilled. And there's the Latin phrase mutatis mutandis. It might be not quite in the same way as the right exists in the general community, but that within the detention setting, people with disabilities are entitled to, for instance, the Article 19 guarantees of living independently and being included in the community. So that's the right to enjoy access to all aspects of life in the detention setting on an equal basis and not to be segregated based on your disability, which of course can include, it's very common to put people with psychosocial disabilities in a separate mental health unit within the prison where they're essentially being treated as criminals and mental patients with all the repression related to both of those designations. And so instead, we're getting away from the that kind of medical model segregation. We still have to deal with, with issues that can come up about prison reform and prison abolition, and whether imprisonment is a good way to deal with people who have committed crimes. What is a crime? Should certain things be crimes? And that is essentially, for the most part, left outside of the CRPD, although it's worth noting that the CRPD committee has taken on a pretty consistent practice of recommending restorative justice and essentially diversion, alternatives to incarceration, to treat incarceration in the criminal system as a last resort. And they specify that these measures, these alternatives to incarceration and restorative justice, cannot include anything that amounts to mental health commitment or a requirement to comply or participate in mental health services. So I think that's very positive, where the CRPD committee could actually play a leading role in encouraging criminal justice reform in a very good direction, because these are reforms that have a lot of potential, and yet often in practice they are requiring people to comply with mental health services. So I think the CRPD committee, by specifying that it can't include that, can push things in a positive direction. So I have this slide on the drafting history. I think I'm not going to say too much about that, except that I think it's worth noting that the text of Article 14b, what I read about the existence of a disability shall in no case justify a deprivation of liberty, that came from the WNUSP advocacy and text proposals, and it had various transformations in different texts, and significantly some states proposed adding terms like solely or exclusively to say that there should be no deprivation of liberty based solely on disability. There should be only, can't remember how they put it into the actual adopted version, but to add somehow that the existence of a disability in itself or exclusively shall in no case justify a deprivation of liberty. And those proposals were rejected every time, and CRPD committee in their guidelines on Article 14 actually pointed out something that I had forgotten, that there were states that spoke against the inclusion of those proposals, not only civil society, and it wasn't just a passive failure to adopt them. It was states also agreeing with us that we don't want to open the door to these kind of, to the mental health legislation that includes criteria like danger to self or others or need for care and treatment. So I'll leave the rest of it and go on, but you can read the slides in full if you want to. Before the CRPD committee started its work, there was some early, even before the CRPD committee started its work, the Manfred Novak report, Special Rapporteur on Torture report from 2008, he took a good step forward in the interpretation by saying in paragraph 44 of that report that involuntary treatment and involuntary confinement are contrary to the CRPD, and he contrasted this with earlier non-binding declarations like the Principles for the Protection of Persons with Mental Illness. It was important. These early interpretations were really crucial, and I personally participated in quite a bit of advocacy on this, because we knew that there was always going to be contestation of the interpretation of this text, even though we understood it to mean that there could be no deprivation of liberty based on a mental health diagnosis, or in mental health institutions. And actually, what I didn't say from the previous slide, the chair of the working group that was making the first text of the convention summarized the discussion by characterizing that provision on the existence of a disability shall in no case justify a deprivation of liberty. He characterized it as a pure non-discrimination and said it was a balanced text, and that a person with a disability who is a danger to others should be treated the same as anyone else who is endangering the community. And that was, no other state, raised their flag to disagree with that. And although the working group chair I mean, his comments were not necessarily, were not legally significant. I think it was extremely helpful that he said it, and that was part of what made me feel a bit more comfortable in the negotiations, accepting that yes, the interpretation made sense, that this was going to be, the interpretation was going to be that you could not confine people in psychiatric institutions the way that we are seeing all around the world. That has been enshrined in the mental health laws. So the early interpretations were very significant to develop within the United Nations some jurisprudence saying that yes, this is what it means. We're not going to try to interpret this away. We're not going to try to bring back this understanding of solely into the text. There was a 2009 thematic study on legislation required to implement the CRPD, and they similarly started to bring in this interpretation. I can share that with you if I haven't done so in the course materials. I think the main, I don't actually have that clear on my screen to bring up. But I think that, the main thing that I want to say about it is that they started to develop that interpretation, and it's important because there are still, you will still, when you see legislation in various states, you will see that one of the ways that they try to keep the status quo on mental health legislation is to bring back that term solely or exclusively. So we see that in India's Rights of Persons with Disabilities Act, that they say there's a right to liberty, that people with disabilities cannot be deprived of their liberty based solely on disability. Well, thanks very much for, for nothing, for just subverting the intent of Article 14 by including this word that was rejected. And it's something to watch for and to be careful of. The OHCHR study actually is pretty significant, and if you take a look at it at paragraphs 48 and 49, you'll see that the CRPD committee picks up a lot of their ideas. Actually, I do want to see if I can find it, because there's something to okay, it's not going to be that easy to find. It's worthwhile noting from the OHCHR study that they included a phrase that legislation, that it's not automatically it's not automatically wrong or prohibited to deprive people with disabilities of their liberty based on a motive to prevent violence or for care and treatment, but that it has to be delinked from disability. This has to be only if it's being done on an equal basis with others. Now, there's two ways to interpret that. One way is to say that this is a kind of opening for states to just say, well, we're not going to talk only about putting people with disabilities in a confined setting on a basis of preventive detention or care and treatment. We're going to have this for everybody, but of course but in a sense where we know that the real motivation is to maintain the existing system. I feel like I'm kind of getting into something that may be a little too complicated if I don't actually have it in front of me. So I think I'm going to postpone that for now. I will get into that a little bit more later. This controversy about, can you create disability neutral laws that actually do the same thing as mental health laws? And my answer is always going to be no. You can't just get around Article 14 or any other provision of the convention by changing the words around and saying it's disability neutral, because it's always going to be a discriminatory purpose and a discriminatory effect. It's inevitably going to have the worst impact on people with disabilities. And we all know that the purpose starts out being discriminatory, because the aim in trying to create these kind of laws is not going to be, in general, somehow protection of the public safety on a non-discriminatory basis, but it's going to be, well, you want to keep confining people with psychosocial disabilities, so you're going to create something that doesn't mention psychosocial disability. So I apologize for not having that text right there, and we'll take a look at it some other time. The early CRPD concluding observations, you see how they developed it carefully, review and repeal laws that allow deprivation of liberty on the basis of disability, including mental, psychosocial, or intellectual disability, and ensure that healthcare services, including mental health, are based on the informed consent of the person concerned. And then they experimented with other ways to say it. They addressed the laws that that include this criterion of danger to self or others, saying that that's contrary to the convention, and urging the state party to take all necessary measures, legislative, administrative, and judicial, to ensure that no one is detained against their will in any kind of mental health facility. So that's bringing it around to showing that it's not necessarily only when there's specific mental health legislation, it's when anyone is confined in this disability-specific setting, it's going to be treated as contrary to Article 14. And thank you, Emmy, for finding those paragraphs and sharing it in the chat note. Yeah, I think, yeah, so OHCHR, in their study, they were very clear about the obligation to abolish all of these legal provisions authorizing institutionalization of persons with disabilities without their free and informed consent, including as well as provisions authorizing preventive detention of persons with disabilities on grounds such as the likelihood of them posing a danger to themselves or others, in all cases in which such grounds of care, treatment, and public security are linked in legislation to an apparent or diagnosed mental illness. And then they say this should not be interpreted to say that persons with disabilities cannot lawfully be subject to detention for care and treatment or to preventive detention, but only that the legal grounds upon which restriction of liberty is determined must be delinked from the disability and neutrally defined so as to apply to all persons on an equal basis. Now, my position is you can't start out from saying we want to subject persons with disabilities to detention for care and treatment or preventive detention, and we're going to somehow craft legislation that applies to everybody, that is really designed to continue these practices of detaining people with disabilities. I think that's a discriminatory purpose. And I think it's wrong to extend restrictive practices that are discriminatory to the whole population. If society has gotten along without restricting the liberty of the whole population on these grounds until now, I think it needs to be highly suspect and questionable if you're going to extend restrictions of liberty. And I think we would need to start with, I think it would only be legitimate if you're actually starting outside the disability context. If the state or society is noticing, hey, we have a problem, there's too much violence and we think preventive detention is the answer. Well, how are you going to decide who to preventively detain? On what criteria are you going to base that? I think it's always a bad idea. I think it's always going to end up being discriminatory, whether based on race or ethnicity or disability or class. And I think it's always going to be a bad idea. So my view is that OHCHR was essentially taking a strictly legal kind of position and saying that people with disabilities, that CRPD Article 14 in itself doesn't prevent a state from enacting preventive detention or detention on the grounds of care and treatment, but it has to apply equally to everyone. And I actually do think that Article 12, legal capacity, prohibits a state from enacting detention for care and treatment, because it would clearly be contrary to a person's exercise of legal capacity to put them in detention on the basis of care and treatment, which is essentially paternalistic. It's a best interest model, which the CRPD committee has said does not apply to adults. So, okay, there's the development of the standards in CRPD Committee's General Comment Number 1 and guidelines on Article 14. In General Comment Number 1, they say that institutionalization without the person's specific consent violates Articles 12 and 14. Psychiatric or other treatment without the person's free and informed consent violates Articles 12 and 14 and infringes Articles 15, 16, and 17. And I'm not sure if I mentioned this. I may have mentioned this in the legal capacity discussion, but the presentation that I did in Galway on free and informed consent goes into what should free and informed consent look like? What is the positive right to free and informed consent, and how is the right to free and informed consent different under the CRPD when you start out from a point of view that everyone has legal capacity, as opposed to free and informed consent where an assessment of mental capacity is actually treated as part of the informed consent. So it becomes a gatekeeping. It becomes a way to, it becomes not a right of the person, but actually a way to control the person and to serve as gatekeeping about when and whether and how the person can exercise their right. The Article 14 guidelines, that entire document is really necessary to look at. On the bulk of that document really is focused on the prohibition of detention based on disability, detention in mental health context, forced treatment. There's also some very good material on the prison context, and including mostly focusing on the impact on people with psychosocial disabilities. And that's because we and I in particular have been very active in advocating this with the CRPD committee. And not just myself, but a few of us have done side events with the committee and presentations and put in shadow reports dealing with this question. So they focus on people with psychosocial disabilities also in the prison context, because that's most of what has been presented to them. But there have been other issues as well related to accessibility that they have had presented to them, and so they deal with that also. And they address this, they say there's the absolute prohibition of detention based on actual or perceived impairment, including for reasons such as danger to self or others, saying that this is discriminatory and arbitrary. They discuss the rejection of the solely term in the ad hoc committee. They say that involuntary commitment on mental health grounds violates the ban on disability-based detention in Article 14, and also violates the right to exercise free and informed consent in healthcare based in Articles 12 and 25. And that's a very good point, because if you are detaining someone based on their supposed health, health status, which is also a disability, it's violating the ban on disability-based detention, and that in itself violates the right to exercise free and informed consent in healthcare, because whatever your health status is, you have a right to exercise free and informed consent about how to deal with it. And then they also mention, again, as they do in concluding observations, the obligation to ensure mental health services are based on a person's free and informed consent. And they include for the first time, well, they had done it in concluding observations, that's why it's also here in the guidelines, but they say explicitly that the elimination of forced treatment is required because forced treatment is one of the practices that violates Article 15, the right to be free from torture and other cruel, inhuman, or degrading treatment or punishment. More from the guidelines on Article 14, detention based on danger to self or others, or need for care and treatment, or other reasons linked to impairment or health diagnosis is contrary to Article 14. So they're saying that these grounds are linked to the impairment or health diagnosis, which I think is accurate, the way it's treated and the way it's characterized in legislation. We don't see usually general legislation applicable to the whole population on these grounds. And if we did see such legislation, or if we do see such legislation, it would need to be analyzed under Article 5 and Article 2, whether there's a discriminatory purpose and effect on people with disabilities. So the committee makes the comments that people with disabilities are perceived as dangerous when they resist treatment. That's a very good point. It's not the only way that people can be perceived as dangerous, but I think it's accurate showing how that links to why they want to put people in these so-called care and treatment institutions when they perceive the person as dangerous. And it's, clearly, even if it wasn't about treatment, it would be wrong. But in practice, and it would be prohibited, but in practice, there's often a linking of the two concepts in a way that just amplifies the discrimination. They make the point that everyone has the duty to do no harm. The criminal law and other law applies, and laws that divert people with psychosocial disabilities to a separate track, including mental health laws, typically have inferior due process and violate Articles 13 and 14. So Article 13 is on access to justice, and they're bringing in the due process right. Then they make the point that the freedom to make choices includes the freedom to take risks and make mistakes, and that has to do with legal capacity, and we have the right in anything that is said to be a health measure, a health intervention, or a treatment, or a hospitalization, has to be based on free and informed consent, and we have the right to take our own risks and even to define the risk for ourselves, because many of us would certainly see psychiatric drugs as a lot more risky than not taking psychiatric drugs. And, you know, we have the right to make our own mistakes and not to have other people make mistakes for us that can be truly devastating to our lives. So the CRPD committee reiterates the obligation in the general comment to respect and support people with disabilities decision-making in emergency and crisis situations, to abolish forced treatment, the obligation to abolish forced treatment, to provide accurate information about service options and make available non-medical approaches. So it's good to have that. That's paragraph 22 in the guidelines. It's also in the general comment. It was paragraph 42 of the general comment, and it's good to have that as a succinct statement that applies especially to the mental health situation. You know, that they have to abolish forced treatment. They can't say that we need to do forced treatment or forced hospitalization because it's a crisis or emergency. No, they still have to respect our decision making. They have to provide accurate information about service options, which is free and informed consent. Don't just hand me a pill and say this is going to make you feel better. You have to actually provide accurate information based on whatever is known about this particular substance you're making available, and make available non-medical approaches. You know, what are the various options? You can't just say, well, you have the choice between this pill or that pill or electroshock. There have to be non-medical approaches made available. And then in the end, you always have to respect the person's choices. Don't keep harassing them if they really don't want what you're offering. They also mention in the guidelines, in this context of respecting and supporting the decision making of people with disabilities in emergency and crisis situations, that if it's not practicable to determine the person's will and preferences, we use the best interpretation of will and preferences and not a best interest determination. And I think that there sometimes it's not really clear, and we probably, as a community of people working on the CRPD, need to do more to develop what the best interpretation means, whether there's a clear line between best interpretation and support and accommodation to understand and determine what the person's will and preferences actually are. Does best interpretation apply only when the person is in a coma or medically unconscious? Or are we talking about best interpretation as if a person is simply not communicating? They're not medically unconscious, but they're just not communicating. They're not responding, or they might be saying two contradictory things. Is it best interpretation then I don't think so. I think then we're still in the realm of support and accommodations to determine the person's actual will and preferences, and you don't take them into a psychiatric institution or administer a drug to them until it becomes clear whether that's what the person is actually wanting. You spend the time to work with them and figure out what is going to be the best, create a calm environment and all, um, whatever can be developed as good practices, as initial ways of just, um, you know in a human way of relating to people, making the situation the most comfortable. Article 14 and criminal charges are addressed in the guidelines, requiring humane living conditions in both institutions and in prison. So that's sort of a crossover paragraph in the guidelines, not only relating to prisons, but so long as institutions are still existing, there is an obligation to ensure that living conditions in them are humane, and also in prisons. And here we see what they say about applying Article 19, the right to live independently and participate fully in life in the detention setting with equal access to areas and services. That sounds mostly like it's about physical access, but it also would include such things as, in my view, it would include, which I've advocated for, such things as non-discrimination in eligibility for various kinds of programs in the prison, like for work and study, that sometimes there are such programs and they exclude people who are labeled with mental health conditions, which would be discriminatory under the convention. They address, they say the declarations of unfitness to plead or capacity to be found criminally responsible and detention based on such declarations are incompatible with Article 14 and should be repealed. Now, I'm not quoting directly, I'm paraphrasing, and mostly I'm condensing the actual words of the guidelines. And so, don't quote this directly, check it against the guidelines, because I'm doing my best to be accurate, but what I'm saying is a paraphrase and not the exact wording. And that states have to eliminate security measures on those found criminally non-responsible, including security measures that involve forced medical and psychiatric treatment. So here we are seeing the CRPD committee taking on board something more substantive about equal justice in the criminal setting. Many of us in the user and survivor community have advocated against the insanity defense, for the abolition of the insanity defense, although it is contentious in the sense that where prisons are extremely harsh and psychiatric institutions, or whatever the institutions are that a person is sent to after an insanity defense, may be less harsh, then we want to be careful in how this would actually get implemented, and we may not actually want to implement that right away. I do think in principle the insanity defense is contrary to the equal obligations that all members of society have to one another, and it's a way of saying that people with psychosocial disabilities are not morally responsible, are not moral actors, and I think that's extremely problematic. I think it's moral being I think moral agency is an aspect of personhood and legal capacity. So the CRPD committee isn't addressing it in Article 12, but I think there's a linkage to Article 12 in the language when they use this term of incapacity to be found criminally responsible. Now, they're also saying declarations of unfitness to plead or incapacity to be found criminally responsible. They're not saying explicitly what happens if you have an insanity defense that, as in common law legal systems deriving from the law of England, the insanity defense is an affirmative defense that a person's lawyer would raise in the trial, so they would theoretically have all the due process rights, and this would be a determination at the end of a trial. And the committee has not explicitly said whether that is a different situation, but they did characterize the law of Kenya as such a declaration of incapacity to be found criminally responsible that was incompatible with Article 14, when in fact the law of Kenya was a common law system with an insanity defense. And I would have to check the details, but I recall checking into this at the time the concluding observations on Kenya came out, and that's what it was. It was an insanity defense that was part of a trial, and the committee did characterize it as one of these declarations of incapacity to be found criminally responsible. So if you're interested, we can discuss more about this. I have an article called "Rethinking Criminal Responsibility" that's in the course materials, and yeah, if anyone wants to explore that in your paper or in the class discussion, that would be great too. As I mentioned, the committee says restorative justice and diversion are preferred, and it must not transfer the person to mental health commitment or require participation in mental health services. So another part of the guidelines I would characterize as falling under the right to access to justice in relation to mental health commitment and as a form of arbitrary detention. They say that monitoring of institutions and review of detention do not condone forced institutionalization. Monitoring is required under Article 16.3 and Article 33. And I mean, I think that monitoring is an affirmative obligation under the CRPD. Article 16.3 talks about the obligation to monitor services and facilities designed for people with disabilities. So it doesn't use the word institutionalization, but clearly that would be, that would be a big part of what needs to be monitored. Any place where people with disabilities are in fact confined, or a situation is of congregate living where people are in a more vulnerable situation. And so I think they're saying that we need to have this monitoring so long as the institutions exist. And what they don't say, which I would certainly advocate, is that monitoring bodies or monitoring mechanisms that go into institutions should be part of pressuring the state to live up to its full CRPD obligations, to eliminate all arbitrary detention, i.e., release everyone who doesn't want to be there, and to work on phasing out the institution itself by working with people on the basis of respect for their legal capacity and self-determination as what they want to do in their own lives, what kind of living arrangements they want. And they say that the purpose of review of these forms of detention is to challenge arbitrary detention and obtain immediate release, and should not extend the arbitrary detention. Now, that's a little bit circular reasoning that they keep using the term arbitrary detention, but I think we need to remember that they characterized all the internment against a person's will in mental health facilities as being arbitrary detention. So there needs to be some access to review so long as these systems exist, and the review so long as these systems exist, and also perhaps as a transition, there will always need to be some access to a review mechanism if a person alleges that they're being held somewhere against their will. So let's say we abolish the mental health laws, and some countries have never had mental health laws, but a person is being detained against their will in a psychiatric facility. They need to have access to some kind of review mechanism to go before the court and say, hey, I'm being arbitrarily detained because I'm being locked up in a mental health facility, and the court needs to be able to order that the person be released. And then the committee says that there's a right to remedy and reparation for the arbitrary detentions, and quotes from the Working Group on Arbitrary Detention Basic Principles and Guidelines. And this quoted material I was involved in developing, and we it's talking about what a court could actually do if they have an appropriate mandate, if they are enabled to apply the CRPD directly in the national courts, or if there's any way that they can possibly fulfill their obligation to comply with the prohibition of disability-based detention. So individuals must be informed about ways they can promptly and effectively secure their relief, including injunctive relief, and that what such relief should consist of, what courts should be able to do, should consist of an order requiring the facility to release the person immediately and/or to immediately cease any forced treatment, as well as systemic measures such as requiring mental health facilities to unlock their doors and inform persons of their right to leave, and establishing a public authority to provide access to housing, means of subsistence, and other forms of economic and social support in order to facilitate deinstitutionalization and the right to live independently and be included in the community. Such assistance programs should not be centered on the provision of mental health services or treatment, but free or affordable community-based services, including alternatives that are free from medical diagnosis and interventions. Access to medications and assistance in withdrawing medications should be made available for those who so decide. So that's a kind of sketch of what it might look like if a court would want to and be empowered to order systemic measures in addition to releasing individuals who come to them one by one and say, my rights are being violated, I want to be released. And I think it's important to imagine and envision how it could actually work, and for lawyers in any countries where it's possible to be creating their own strategies that are appropriate to the legal and political and social and economic context. I think it's just important to think about systemic as well as individual measures, that courts should have the power and the mandate, and can be urged to release people who claim their CRPD rights, and also that they should be able to order systemic measures to affect more individuals at a time, so it doesn't have to be people coming one by one. Okay, so I'm going to briefly mention here, since I mentioned the working group on arbitrary detention, the basic principles and guidelines on remedies and procedures on the right of anyone deprived of their liberty to bring proceedings before a court. It's a very long title. It's a good document that, it's in some ways it's worth reading the whole thing, but Principle 20 and Guideline 20 in particular are the ones dealing with people with disabilities. And they address the obligation of courts to uphold the CRPD prohibition of impairment-based detention. They don't reference it to the CRPD except in some footnotes in one version of the document. But they're addressing simply the obligation of courts to uphold the prohibition of impairment-based detention, that there can be no unfitness to plead in criminal trials. They address the right to legal capacity and the distinction between legal capacity and mental capacity, and the right to have access to support in exercising legal capacity in relation to, it's generally, but also in relation to both services and processes to challenge arbitrary detention. And they include that mental health services should be based on the person's free and informed consent. Now, there was some footnote in one version that is still being circulated of this document that raised questions as to whether the working group on arbitrary detention is really fully moving to the CRPD standard. We've now received some good indications that they are. There was in, I think, 2015 or 2016, I think 2016, a decision in a case in New Zealand. It was one of these cases where a person was, it might have been a sex offender case, I'm not entirely certain, but it was one of these cases where a person is convicted of criminal charges, and then when the sentence ends, they're subject to further civil confinement on the basis that they were being considered a danger to themselves or others, a danger to others. And the working group found that this was discriminatory detention based on disability. And discriminatory detention is one of the categories of arbitrary detention that they deal with. And typically they will say, if a case falls under one or another of these categories of arbitrary detention. So they said it was discriminatory based on disability. Then they came out together with the Special Rapporteur on the Rights of Persons with Disabilities and the Special Rapporteur on Health. They came out in urgent appeal in a case of forced psychiatry in Norway. It's a very detailed urgent appeal, going into a lot of nuances that are very typical of situations where people are locked up in psychiatry and being subjected to forced treatment. So I I will try to remember to link that in the course materials if I haven't already done so. It's very well worth reading um, to show how the advocacy is being framed and understood. I mean, I say that because the urgent appeal itself is written by those mechanisms, the working group and the two special rapporteurs, but it is also based on advocacy brought to them by the person and their and their legal, legal representation in the sense of the lawyer who is representing the person. So I think it's very well worth looking at to show the extent to which these mechanisms are understanding the issue, and a good way of framing similar cases if people are interested or have the ability to work on such things. Then the Working Group on Arbitrary Detention also had a visit to the United States. They do country visits as well as individual cases. They met with survivors in a couple of different cities, and we also sent them written information. And it came out pretty well done. They do say clearly and unequivocally that involuntary commitment to hospitals or institutions is prohibited. And so in the US, we're starting to talk about what we can do with this, where we want to take the advocacy, because it's the first time we've gotten a specific recommendation from the United Nations to the United States saying that involuntary measures in the mental health system have to be prohibited. And so we can also then use that in advocacy to treaty bodies, because we're not yet a party to the CRPD. We are a party to Convention Against Torture and Covenant on Civil and Political Rights, and so those, and also to CERD, Convention on Elimination of Racial Discrimination. So conceivably, we can bring these recommendations of the Working Group on Arbitrary Detention to to those treaty bodies and slide it in that way to have them, to ask them, and they may urge the US to comply with these recommendations of the working group. I'm going to go back to, which one should I do first? Now I'll do some of these. Other positive things happening, the Special Rapporteur on the Right to Health. Well, the Special Rapporteur on the Right to Persons with Disabilities has also been very consistently supportive of, the abolition of forced psychiatry, and she's working on there will be reports, I believe, on both Article 12 and Article 14. So that's one thing. Another thing to keep in mind, the Special Rapporteur on the Right to Health made a report recently this year on mental health, human rights issues, and it's very good because it's detailed. It's sort of, I'd say, cautiously against the medical model. There's many good points, but it's not as completely against the medical model as some of us would wish. And also, it's not entirely in line with the CRPD standard, as he is saying there's an obligation to create non-coercive support measures and eventually eliminate coercion. So he's not saying that there is an immediate obligation to ensure that people get released if they don't want to be locked up in psychiatry, but I think his report is already starting to be enormously influential. And even though I don't agree with him in terms of the standard he's promoting, we have to insist on the full human rights standard, that it's arbitrary detention and people have a right to immediate release, period. I think it's still very useful that this report exists. Also, the World Health Organization, which is not a human rights mechanism, but also highly influential throughout the world, they have been advising states that involuntary hospitalization and involuntary treatment is contrary to the CRPD. So if a state says to the World Health Organization, here's our new mental health bill, what do you think? They're going to get the response that these provisions authorizing involuntary commitment and involuntary treatment are contrary to your obligations under the CRPD, and you should not have them. Then they may also say, well, if you do have them, you should make them, not so bad. But at least they are saying that it's contrary to the CRPD. It should not be there, and they withdrew their recommendations that they had earlier made to say that states should enact mental health legislation. Now they are not saying that, and they're recommending that these coercive legislations should be repealed. They have out in a pilot form a set of training modules based partly on CRPD, and they are in principle upholding. They are upholding in principle that that the forced and coercive measures have to be abolished. And I think in some of the details, there's a lot of room for improvement in how they're applying that. I've been making detailed comments. They're going to come out with a revised version of the modules, and other people are welcome to make comments. I can try to send links to that if I remember, or you can remind me, or you can find it. You have to specifically request access to the platform to leave comments, but they're very open to interested people doing that. Then there was some things contrary to the CRPD. The Human Rights Committee, General Comment 35, paragraph 19, was treating involuntary hospitalization as a last resort. That was in 2014. And the Subcommittee on Prevention of Torture, which is the human rights treaty body for the OPCAT, the Optional Protocol to the Convention Against Torture, has said that involuntary confinement and involuntary treatment are actually at times necessary to safeguard the right to health and the freedom from torture or other ill treatment, and they use a functional capacity test. That's the most directly contrary to CRPD, since the Human Rights Committee was really just saying, well, we know it's a bad thing, but it's a last resort. So they are closer to actually potentially moving towards accepting the CRPD standard, while the SPT is actually coming right out and saying, no, actually, this is, because the CRPD committee is saying that it's contrary to the right to health, it's contrary to the right to be free from torture and other ill treatment, and the SPT is saying exactly the opposite. So I think there's a lot of work that we have to do in that regard. It's not really exactly clear how to proceed with that treaty body. So I think, eventually there has to be some change in how. I think I think that there have been. Well, I think that's something that we are at least I'm not sure if anybody is working on that, working on reaching out to the SPT at this point, but it's something that will keep having to be done. And the Article 14 guidelines were prompted in part by these contradictions to the CRPD standards that had been coming up. Now, one other more detailed set of standards relating to liberty that is in the UN and that is partly in compliance with CRPD, but partly um, not complying with it, is the revised standard minimum rules on the treatment of prisoners. Now, the way that it's non-compliant with CRPD is the same as the old version. Hold on a second. No, they can't come in anyway. All right. Excuse me. Hold on. Hello, please leave me alone. I'm having a late checkout. I'm very sorry. I'm in a hotel, I'm on the road, and continuing. So the standard minimum rules on the treatment of prisoners, it's non-compliant in the revised version, the same as it was in the original, but I'm going to simply discuss the revised one, which is also called the Mandela Rules now. The revised version was adopted in 2015. WNUSP was the only DPO, Disabled People's Organization, participating in the reform discussions. It was a difficult process. I worked on it. Annie Robb from South Africa made an amazing contribution the year that it was in Cape Town. She did some very excellent advocacy that resulted in some of the positive incorporations, especially in that we'll see on the inclusion of a provision on the rights of people with disabilities. So, being the only DPO, although there were useful submissions from the Special Rapporteur on Torture at the time, Juan Mendez, we had limited success. There were some of the criminal justice organizations, the criminal justice related NGOs like Prison Reform International, Amnesty International, they were advocating strongly to keep the insanity defense, to keep in essence, the transfer of people to mental health institutions instead of prisons. And I don't think they were necessarily coming from a terrible place, but there wasn't a good opportunity or a good process among the NGOs that would have allowed for discussions to happen that would have actually looked at what people's concerns were and tried to come up with a solution that made sense. So this is what we have that I would pull out as relevant from the standard minimum rules. Rule 5.2, prison administrations shall make all reasonable accommodation and adjustments to ensure that prisoners with physical, mental, or other disabilities have full and effective access to prison life on an equal basis. So we had already started with the advocacy for the SMR to promote this Article 19 way of seeing things. And I believe that the Special Rapporteur on Torture, Juan Mendez, took that up in his recommendations as well. So we have that coming into the rule here, which is positive. Rule 32.1, we were also very strongly advocating generally for free and informed consent in health, which the CRPD is, probably one of the strongest treaty bodies on that issue right now, given the relationship with legal capacity, that we're talking about free and informed consent by the person concerned, period. And so we were bringing that in obviously WNUSP as a leading organization doing that. So Rule 32.1, the relationship between the physician or other healthcare professionals and the prisoners shall be governed by the same ethical and professional standards as those applicable to patients in the community. In particular, and I've pulled out a few of them, adherence to prisoners' autonomy with regard to their own health and informed consent in the doctor-patient relationship. Now, that's good, but I question why it didn't simply say, mention the right to free and informed consent of the person concerned. And throughout this process, there were tensions between the human rights oriented NGOs and the human rights mechanisms of the UN and the mechanisms of the UN and governments related to prison management and policy related to crime issues. So this was being negotiated in Vienna, which is the headquarters of the UN Office on Drugs and Crime, not in any of the human rights parts of the UN. And some of the states participating were essentially wanting this to be about good practices in prisons rather than human rights. So that may be why it doesn't specifically say there's a right to free and informed consent by the person concerned. Then, and I would hope that it's actually interpreted as preserving and protecting such a right. Now, I'll also say that despite Rule 5.2 talking about reasonable accommodations for people with disabilities, we did not get into the general non-discrimination provision in the SMR a mention of disability. And the reason was, it's a very foolish and bad reason, because disability, the proposals to add to what had already been there, which I believe was race and sex and probably religion and a few other things, they wanted to add disability and they wanted to add sexual orientation. There were some states who refused to add sexual orientation, and then there were one or two states who said, well, if you don't add sexual orientation, we're not making any change, so we're not going to add disability either. So, that's very unfortunate on both of those grounds. And it means there's no specific protection generally against discrimination based on disability, but there is the catch-all other status protection against discrimination based on any other status in which disability should be included. And given that there is a human rights treaty to which over 170 countries or states parties, i.e. the CRPD, there's a clear obligation to not discriminate based on disability in the general human rights framework at this point, even though it's not specifically mentioned here. So there should be, in relation to free and informed consent in health, there's a clear argument that there should not be any discrimination based on disability in the exercise of free and informed consent in the doctor-patient relationship, on an equal basis, the same as in the community, and that this includes or incorporates the CRPD standard of legal capacity, that it's based on the free and informed consent of the person concerned, no functional capacity test, no substitute decision making. But there's no treaty body, there's no monitoring body for the SMR, so it's going to depend in particular states who is applying what. Are they applying the SMR? Are they applying the CRPD directly and the guidelines on Article 14? How is all that going to interact with each other? And how are they, or if they're going to take the stance of the SPT, the Subcommittee on Prevention of Torture, and say that we're using a functional capacity test and we think forced treatment is necessary and it's a good thing sometimes. Then they talk about also the confidentiality of medical information, but they make the caveat, unless maintaining such confidentiality would result in a real and imminent threat to the patient or to others. And, that's certainly problematic, I think, under the CRPD. And, I think we would have to sort of parse and go through what that means in a detention setting. And is this really and mostly about people with psychosocial disabilities? What kind of situations are they really thinking about? Are they thinking about someone who is HIV positive, and in a situation where their blood is coming into contact with someone, if there's been some acts of violence? And can you use universal precautions in that context to avoid breaking the confidentiality? I mean, I don't know what kind of situations they're envisioning. And then they say there's an absolute prohibition on engaging actively or passively in acts that may constitute torture or other cruel, inhuman, or degrading treatment or punishment, including scientific or medical experimentation that may be detrimental to health, such as removal of cells, body tissues, or organs. So, if a state is really wanting to apply the CRPD, if they're applying the good aspects of the jurisprudence from the special rapporteurs on torture, are we going to see a prohibition of forced psychiatric drugging, forced electroshock coming in there? I think given the overall conservative tenor of the SMR, it may be doubtful, but it's an opening. Other problems, there's a correctional model of imprisonment that goes along with the medical model of mental health. Now, the correctional model of imprisonment uses language like, we're going to assess the prisoner's individual needs for rehabilitation and provide them individual treatment. So it sees prison, it sees the status of a prisoner as somebody who has fallen down somehow, or who is somehow in a sense impaired and is in need of rehabilitation. It's almost as if they're seeing having committed a crime as almost as if it's a disability or an impairment, as something that means there's something wrong with the person that they need to change. So it's seeing people as needing to change once they've been convicted of a crime, and that the prison is supposed to undertake to change them through individualized treatment tailored to that person's supposed needs. But it's not about interacting with the person to see, who are you, what, to see what do you want out of life. But it's a more negative way of looking at the person to see, what's wrong with you that you failed in this way to comply with your obligations to society. During the process of the SMR review, some of us, including myself, were opposing that way of looking at things. And some of the advocates who participated in a meeting with the special rapporteur on torture were very strongly, promoting the opposition to this correctional model. Rather, it should be, okay, you're in prison because, society is actually punishing you for something you've done. But once you're there, don't invade or intrude on the person's individual boundaries by trying to change them. You know, they have a right to just be who they are and to change if they want to change. They're already being punished, and punishment shouldn't include subjecting to the person to some kind of behavior modification, whatever that may look like. And I think it's related to the medical model. It's very strongly related to the medical model of mental health. So I have some references to which rules you might find that in. Then you have, this is where it really is contrary to the CRPD, Rule 109, which rules 109 and 110, this is the insanity defense and transferring people to mental health facilities. That was rules 82 and 83 in the old version, just changed slightly, not really very much. I think they changed the language. They're not using the term insanity anymore as they did in the old version. So Rule 109 says persons who are found to be not criminally responsible or who are later diagnosed with severe mental health disabilities and or health conditions for whom staying in prison would mean an exacerbation of their condition shall not be detained in prisons, and arrangements shall be made to transfer them to mental health facilities as soon as possible. So first I'll say it's actually not clear that that clause for whom staying in prison would mean an exacerbation of their condition. It's not clear if that refers to the persons who are found to be not criminally responsible. I don't think it can, because if you're not criminally responsible, I don't think there's a legal basis to detain you in a prison. But that may depend on how a particular state's laws are actually written. But I think in general, this paragraph, this statement assumes that mental health facilities are better than prison. It's not saying that the person will be offered to go to a mental health facility. It's not specifying whether going to the mental health facility is going to mean then you're subjected to the whole regime of forced treatment, and it's a detention based on mental health, and the detention, the length of the detention is based on whether a doctor thinks that you are well enough to, or whatever the judgment is, that you should be released into the community. Is it going to be the doctors who are in charge of the actual detention? Or is it only that you are serving your criminal time in a mental health facility, if that happens to be a place that is less harsh, less onerous than prison, and where you could get services if you would want them? That I wouldn't have an objection to. If it's about offering the person, you know, here's what we know about this mental health facility. It may be easier for you to do your time there and you're not going to be forced. That's an idyllic possibility that I don't think really exists at the present time. But if that possibility would exist, I don't think that would be in contradiction to the CRPD. What's in contradiction to the CRPD would be involuntary transfer, assuming that people should be put in mental health facilities. Also, if you find somebody to be criminally not responsible, you know, treating that determination as something that's in between an acquittal and a conviction is problematic, because, you know, setting aside the Article 12 issue and the question of general fairness and treating people with disabilities as moral agents, if you are found to be not responsible for a crime, there's a problem with subjecting you to any kind of measures on the basis of something you're not responsible for. So I think that is inherently that's inherently going to be a detention based on disability, which is contrary to Article 14. And then the paragraph 2 here, if necessary, other prisoners with mental disabilities and or health conditions can be observed and treated in specialized facilities under the supervision of qualified healthcare professionals. It's not specified whether this is going to be with the person's free and informed consent. Clearly it should be. Clearly it has to be if it's going to be in compliance with the CRPD, and then providing for psychiatric treatment of all other prisoners who are in need of such treatment. I don't know why they specify psychiatric rather than the more generalized mental health services. They shouldn't. And then Rule 110, it is desirable that steps should be taken by arrangement with the appropriate agencies to ensure, if necessary, the continuation of psychiatric treatment after release and the provision of social psychiatric aftercare. And again, that really assumes a medical model and a control model. It's not talking about offering mental health services. Rather, it's treating the person as if they are going to need to be controlled through psychiatric drugs and monitored through other kinds of services. So it's, again, this correctional model of imprisonment together with the medical model of mental health. And that entire approach, I think, is contrary to how the CRPD committee is looking at it, although they haven't taken on opposing the correctional model of prison or criminal justice particularly, or not explicitly. Yeah, but I think overall their approach has been, I mean, they've expressed a strong preference for restorative justice, and what the content of that is. Sometimes the content could take on some of that correctional model, that you have to change people and you have to motivate people to want to change their lifestyle through restorative justice. And so I think that that's still going to be something to watch, and that needs quite a lot of development in thinking and practice. The last thing that I will talk about is, this is a little bit anticipating the next segment. The next segment of the course is going to be on Articles 19 and 25. And here I've just pulled out some of the aspects of the general comment on Article 19 that are actually incorporating, the Article 14 standard of the, as they say here, the absolute prohibition of detention on the basis of disability. So I don't think we need to talk about this a lot right now. It's just worth noting that general comment number 5 on Article 19 is a general comment, and it's the committee is treating the guidelines on Article 14 as an important part of their jurisprudence. I'm not sure if it has been translated into all UN languages, which remains a problem, and I don't think that it has yet been placed into a document with a UN document number. So including some of these Article 14 obligations in this general comment, which is translated and has a document number, and referencing the guidelines on Article 14 is is an important step, another useful tool. So where they say that Article 19 is linked to the absolute prohibition of detention on the basis of disability, as enshrined in Article 14 and elaborated in the respective guidelines, and then they footnote to the guidelines on Article 14 that we've mainly been discussing. So this is what I have, and I hope it's been useful to go into detail on the I'm just putting that up rather than have a specific content right now. I guess it won't cooperate with me, but I've gone into detail on the guidelines on Article 14 because I think it's really worth it to know that document and to also know some of the drafting history of Article 14, where it comes from, what some of the controversies are, and how some of the issues come up. What are the different themes in the guidelines on Article 14 in order to use it effectively. So again, I hope it's been helpful to do this rather than something that's really just more conceptual or experiential. And I'm open to comments or questions now or later in any discussion in the group. I have a comment that it has been helpful. Thank you. So I'll just wait another minute or two to see if there's any other comments. And if not, I will close and thank you for coming to the lecture. Okay, I see a question coming. How about detention in the case of psychiatric evaluation before a sentence is determined? I think psychiatric evaluation would still be disability-based detention, whether it was in a criminal context or in a civil context. And if a person is being, say, detained without bail pending a criminal trial, that per se would not be contrary to the CRPD unless it's in some way the person is being treated differently, discriminatorily based on their disability. But if they're being detained if they're being detained simply because they, on the basis of general regulations allowing detention before a trial, and in the course of that they're being subjected to a psychiatric evaluation, I think I would question what's the purpose of the psychiatric evaluation. In my view, there should always be a right to free and informed consent for any diagnostic procedures as well as treatment. And the only possible exception I could see for diagnostic procedures is, say, in the case of a contagious disease that is spread in ways that can't be diminished through behavioral precautions, such as in a situation where there's a respiratory infection that could be lethal, and you come to an airport and they're going to detain you and test you to if you want to stay in that country, unless you want to get on the plane and go back home. They're going to test you to see if you have such and such illness if you happen to be coughing. I don't think that is against human rights, but in virtually all cases, I think diagnostic procedures would have to come under free and informed consent, the same as any kind of treatment or hospitalization. Being remanded to a psychiatric hospital for evaluation would be discrimination. Yes, it would be. I mean, let's say you're arrested for a crime, and instead of being held in the prison, they decide that you should be sent to a psychiatric hospital for evaluation. I think no matter, I think, yes, that would be discrimination, because it would be sending you to disability-based detention that is contrary to Article 14. If you've been arrested for a crime, the state has the right to detain you for that crime under the same rules as have to apply to everybody else. But they don't have the right, just because they arrested you for a crime doesn't mean that they have the right to subject you to some other form of detention that is actually discriminatory. And we've actually had to deal with that question, where sometimes people will say, well, but you were arrested for a crime, they have the right to detain you. But they don't have the right to detain you, to transfer you to some other form of detention that's not criminal, that's discriminatory. Like the same way they wouldn't have the right to transfer. I mean, I don't have to give any other suppositions. That's clearly discriminatory detention, even if they have some legitimate basis to detain you in some other form of detention. And often those kind of detentions for psychiatric evaluation, that's going to be on the question to evaluate you, to determine whether they should declare you unfit to plead or incompetent to stand trial, or whatever the version is in your jurisdiction. And those would also be contrary to the CRPD and discriminatory. So then, yes, the evaluation to determine whether to do this discriminatory thing to you would also be discriminatory, in that, looking at it from that direction too. And any other questions or comments? So if not, I'm going to close and thank you for your attendance and participation. Look forward to assignments and to questions, comments, discussion from everybody in the group discussions. Thank you, and ending.